As we all know, in 1970, New York State abolished its prohibition on abortion, and shortly thereafter, in 1973, the Supreme Court, in its Roe v. Wade decision, made it a constitutional right. In the intervening years, a lot has changed, but not New York's laws. In fact, between 1970 and 1973, the court decision enshrined not only a protection for the life of the mother, but also the health of the mother. So the bill would codify the Roe v. Wade protection for the health of the mother as well as her life, and we further update our statutes. We have always believed that this matter belongs in the public health law, and so we do that, and we remove and repeal sections of the criminal code, the penal code, that relates to criminalizing abortion. And this is intended to ensure that going forward, New York State's women continue to have their right to determine their own reproductive destiny, and that the woman's life and health are protected in New York State statutes. So there's a new section of public health law, and as I said, the repeal of penal law that is no longer appropriate, most of which are unconstitutional. And we also, the practice of medicine has changed over the years. In 1970, there were a number of licensed professions that did not exist, and they now do and are very much a part of ensuring that there is access to health care, largely primary health care, across the state, whether it's a physician assistant or a nurse practitioner, or many women choose to use a midwife for their reproductive health care, in some instances strictly based on their scope of practice, what their scope of practice legally authorizes them to do. There may be, but let me be clear, because in the past there have been some misrepresentations. The scope of practice for a dentist, a chiropractor, a podiatrist, an optometrist does not include anything that in any way would allow them to be involved in a woman's reproductive health care and abortion.